Hello, everybody. Today we're going to be doing for your homework assignment after the Law and Order. We're going to be doing little lecture notes as you've been told. So we left off with arraignment. Now we'll be kind of going into the trial aspects, trial components of the flow chart here. Again, it's reviewing. The booking process, arrest, booking, your initial appearance, preliminary hearing, indictment by grand jury, then you're arraigned, and then finally from there would come your trial if you make it this far. If there's no plea deal, or whatever the case might be, it would end up here. Again, most cases are they avoid this stage. They avoid trial. Sometimes there's a plea bargain that's done prior. But if we were to go to this case, this is where it would happen. So right to the accused. I want to spend some time talking about this. One of the things that law enforcement and our court systems that they are required to protect our due process of law. So what does due process mean? That means now again, due process for most of us, it means very little to us. Because most Americans, most people really don't get into the court system, don't get in trouble. But when you do get into trouble and you are accused of a crime, the due process ensures that you receive a fair trial. So what does that mean? It means that the basic rights that are outlined in the Constitution must be respected and implemented by the court. That's what due process means, that the court systems have to uphold, protect your basic rights, and the courts have to respect that, implement that throughout every stage of the process. That's what due process of law is. You have the right of due process of law, from the criminal aspect, from being arrested, all the way through the trial. So you see that through the Fourth Amendment. Protection from illegal searches and seizures, the exclusionary rule. If something is found to be found illegally, the evidence will be thrown out in court. So again, those are protections. Search warrants are protections for us against the government. So that's one prime example in terms of what right the accused has. Then you have the Fifth Amendment. And again, same thing. There's a few different protections with this. The one means that you have no self-incrimination, meaning that you cannot be forced to testify against yourself. Again, you got to understand it's the state or the prosecutor has to prove your guilt. So they have to lay out a case. They have to find the evidence. You don't need to say anything. It's their job to prove that you're guilty. So you can, if you so choose, you don't need to take the stand. And typically, especially in criminal cases, most defendants, they don't take the stand against themselves. Most of them plead the fifth. So if you ever hear the term "I plead the fifth," that's where that comes from. That means they basically refuse to take a stand and make the court lay out their case. So anyway. If you do take the stand, then you must answer all the questions. Prosecutors must make their case and prove guilt. They might offer immunity to witnesses. So for instance, if maybe somebody might know something or might have been implicated in something, sometimes they can make a plea deal or offer immunity to a witness to come forward if they were involved to make a stronger case against you, who they believe is like the main target of it. Again, anything you say can be used against you in court. So that's why they say with the Miranda rights, they say that anything that you say can be used against you. So that's why you don't need to say anything. Even in the beginning stages with police, you don't need to talk or say anything without a lawyer. So that's really important. Sixth Amendment, some things that are outlined in the Sixth Amendment are you have a right to a lawyer. That was outlined in Gideon versus Wainwright in the court case. So everybody, whether you could afford one or not, if you can't afford one will be appointed to you. So everybody has a right to a lawyer and right to a defense. 2, right to a jury trial by their peers. This isn't required in every case. Most criminal cases are resolved by a guilty plea and resolved before it even makes it to trial, like I said. Defendants can also waive their right to a jury trial and have the judge be the person in charge of that. But again, you do have the right to be tried by your peer, to have a jury. Jury selection, jury duty. This is selected from voter registration, driver's license, or tax lists. They want to have an equal slice of the community, all different aspects, and have everybody has an equal chance of being on jury. So if you registered to vote, or if you have your driver's license, that's how someone could be selected to be on jury. I think I was selected twice. However, both times I went. Once my kids were born, and I asked the court if I can be deferred till later on, so that passed because I was having a baby. And then the last time I went, I actually had to go, but I went for a day, and the case ended up being pled out, so I wasn't needed anymore. So again, that's how that's done. You have a right to a speedy trial. Case may be dismissed if defendant doesn't receive a speedy trial. So what does speedy mean? Well, it's open kind of for interpretation, but you must be told, what you're being charged of. You have to have, a speedy process before you get arraigned, and you have all these, your initial appearance, and they'll set a court date. And then finally, you as a defendant and your lawyer have a chance to confront your witnesses and obtain witnesses. So you can find witnesses that will help your case, and you can confront the witnesses that are going against you. So your lawyer can cross-examine and ask questions to those that are being brought up by the prosecution. Defendants can also obtain a subpoena. So what does a subpoena mean? A subpoena means a court order requiring witnesses to appear in court and testify. So sometimes you might have people who might be unwilling to testify in the trial. Well, if that's the case, you can get a subpoena, court order that basically forces them to do that. And as I said before, your defense has the right to cross-examine witnesses that's brought by the prosecution. So those are all protections by the Sixth Amendment that protects your rights as the accused. And then obviously you have the Eighth Amendment, no cruel or unusual punishment, no excessive fines, solitary confinement, or the death penalty in some cases. It's kind of a state-by-state thing, and even still, the Supreme Court has laid certain demands on death penalty cases. So there's certain death penalty things that were done way back when that are now outlawed now. So like the firing squad and hanging, they want to try to find more humane ways to do it. But some states outright have banned the death penalty. Some states keep it, some states don't. All right, so steps during a trial. Just kind of some procedural things, and I have this in the notes. You don't need to really write any of this down because I already have it for you. But if you were to go into a trial, this is kind of how it would be laid out for you. You would have your opening statement by the prosecution. They would go first. So what is your opening statement? Your opening statement is the introduction. You're usually addressing this to the jury. You're overviewing the case, what happened, the who's, the what's, the where's, the how's, and you are basically accusing the suspect of being guilty, or if you're the defense, you're arguing that they're innocent. So how it goes, the prosecution, they go first because, again, it's their job to lay out their case. They go first, and then the defense will follow up with their opening statement. So both sides will get their opening statements read. Then you have direct examination or interrogation of witnesses sworn to tell the truth. So lawyers will ask witnesses questions in front of a judge and jury, and usually prosecution goes first, and then until the prosecution will bring up all of their witnesses. And again, the defense will have the right to cross-examine those witnesses, which, as you'll see here. The opposing lawyers, so the defense in this case, will have a chance to ask witness questions who the prosecution brings up. And then you get redirect. So you go back to the prosecution, who started the questions, and then they'll have a chance to ask more questions on the follow-up off of what the defense asked to clarify things, or maybe something pops up that the defense brings up. They can clarify those and ask the person more questions. Then you get a recross examination, where now the defense gets a second turn to, if they so choose, to ask questions to a witness. So basically, I guess maximum, you get basically 2 chances to ask a witness a question. The prosecution gets 2, and the defense gets 2. And then will come your closing statement, summary of the important evidence and arguments in the case. The prosecution's last chance to persuade the jury, they go first. So this is the prosecution. They've had witnesses, they've brought all the evidence, they've examined, cross-examined, recross-examined, and then they give the closing. So this is again to the jury, this is what you've seen, this is what you're witnessing, here's our case. So they review everything. And then you would have, and then obviously the defense would have their chance to do their closing statements too. All right, so then obviously would be your verdict and final decision. This is kind of the courtroom jobs that we'll talk more about tomorrow in class. You kind of see this, you have your judge in the middle, you have your court reporter, clerk, you have your witness stand right here, jury box, and then you have your gallery back here, and you have your prosecution and defense right in there. So typically how a typical courtroom is set up. All right, so that is it for today. So pretty easy peasy. I'll see you guys on Friday. You should have all this done by then. And then we'll start reviewing for our quiz test on Monday. All right, have a good night.